Let's talk about motion argument and some of the things that lead up to motion argument and, of course, the basic structure and some of the key tips and key commandments of motion argument. So the first rule of advocacy as it relates to motion argument is tell me what you want. That means you got to know what it is you're asking the judge to do, whether it's to grant a specific form of relief, to grant an order, or to deny the order. Know what it is that you want the judge to do, and as soon as it is feasible, tell the judge what it is that you want them to do. Now, if you want to know about pretrial procedures and kind of how to file briefs and motions, we refer you to King County Local Rule 7. It's one of the most detailed in the nation, which is why we tend to refer you to it. But right now, we're going to talk about argument and the basic structure. First things out of your mouth is who you are and who you represent. If the case has not already been called, say the name of the case so that the record, the record that's being recorded, that's the formal recording for the case, that the record is clear what your case name and number is. But then say what your name is. Tell the judge who you represent, and then, yeah, you got it, tell the judge what you want them to do so that she has a very clear understanding we're headed to this particular place. After you've told the judge why you want him or her to do a particular thing, that's the place then that we start explaining the reasons why. This isn't a deductive A plus B equals C. We're going to save what the mystery is of what you're asking for until the end. Rather, tell the judge right up front what you want and then give them an outline, a roadmap of how you're going to take them there. And that usually involves laying out what the issues are. And so I know that you're thinking to yourself, what about Iraq? Yeah, no, not that Iraq. This Iraq. The issue, rule, analysis, conclusion, which I'm sure you heard about in legal writing. Well, that's where this falls in. This is your roadmap are your issues. And you lay out here are the issues or the reasons why the court should grant what it is that I want the court to do. Provide them the basic rule, whether it's out of a rule or it's case law. You provide the authority, and then the analysis, the reasons why, either the policy reasons or applying the facts to the law, why you should get what you want. And then finally, the conclusion, which surprisingly sounds a lot like what you want the court to do. So here are the 10 commandments for you to think about as you're prepping for your motion arguments. Well, commandments a little strong. We'll call them tips. First thing, rule number 1, are you surprised? Yeah. Tell me what you want me to do. Second, do not read your brief to the judge. The judge probably has read your brief, and they certainly don't need you droning on. You can refer to your brief, but don't just sit there and read the brief. You can use the brief as an outline. You can refer the judge to things that are in your brief, but don't read the brief. Remember, you're giving a synopsis and you have a limited amount of time. Speaking of time, be on time. Don't show up late. And if you do show up late, apologize profusely, explain why you were late, and, well, sort of imply that you'll try not to do it again and make amends to the extent that you can. Don't assume that your judge doesn't know the details of your case. By the flip side, don't assume that the judge does. You've got to kind of control the detail. And by that, I mean, remember, this motion hearing, it's not about the entirety of your case. It's about you getting one specific thing, a specific order. So the judge doesn't need to know all the interesting and gory details of your case. The judge only needs to know those things that help the judge decide the issue that you put in front of them. So control your detail. Don't assume that the judge knows all the details, cares about all the details, but also don't assume that your judge hasn't read your briefing, because the reality is, yeah, we do read the briefs. Number 7, if you're going to cite a case, read it. Don't just read the head note. Head notes are a great way to be misled, and the number of lawyers that cite cases based on the head note, and then when the judge pulls it up and it turns out the case actually held exactly the opposite or stands for a completely different proposition, well, that's a great way to undermine your credibility. Remember, head notes, the ones from Westlaw or Lexis, those head notes are crafted by first-year lawyers who are reading cases and they're crunching things out as fast as they can. They may or may not be accurate. It's a great way of finding cases, but remember, if you're going to cite the case for a proposition, read it, because trust me, your judge will. When you're making your argument, especially if you're doing something that seems very simple and you're in a courthouse or in a location where the convention is always to do a particular thing, I strongly encourage you, do not use the, well, all the other judges have ruled or have done, because most judges know this. One, all the other judges haven't actually done that. And as soon as we hear that, that triggers within us, why is it that they're trying to get us to look at what other judges are doing rather than the reasons why I should do that in this case? The reality is sometimes local conventions can evolve and then the law changes, and so the convention hasn't kept up. And every judge is going to make their own decision. So don't just say all the other judges do this and kind of stamp your foot at the judge. May I suggest a stronger way of putting it is, well, the reasons why the majority of judges in this jurisdiction follow this procedure or do this is, and then give the actual reason. Don't negotiate with the judge. The judge's ruling is not a first offer. After the judge has heard argument back and forth and makes a ruling, that's the ruling. And if you're tempted to then say, wait a minute, I have to make my record that I object to the judge's ruling, you've already done that at least you should have already done that in your oral argument. And if you missed a point, there's something else that you need the judge to consider, well, obviously you're not going to score a lot of points by the fact that you're not saying, oh, Judge, I forgot to tell you, and this is going to change your mind. So make sure that you have all of those points and that you can articulate them before the judge's ruling. But once the judge has ruled, it's okay to ask the judge if you have questions about the ruling. But don't use that as an excuse to then argue with the judge. This is not a negotiation. The judge's ruling is not a first opening offer. And in fact, you may want to either appeal the judge's ruling because it could be wrong, or you may want to ask the judge to reconsider. Generally, it's not going to be a great idea to ask the judge to reconsider. By the way, that's CR 59. It's not a great idea to ask the judge to reconsider right there on the spot. You can do it, but your likelihood of success is not high because the judge has already heard pretty much everything that they're going to hear. It is better to take a step back and craft a well-crafted CR 59 motion for reconsideration that the judge can ponder. I can share with you that I have had lawyers ask me to reconsider on the spot, and I rarely grant them because, again, I just finished ruling on it. I pretty much know what I know at that point. But a well-crafted motion for reconsideration can actually achieve that. So remember, the judge's ruling, not a first offer. Finally, don't get personal. As much and as ardent as you support your client, and as evil as you might think either the opponent or the opposing counsel is, it shouldn't be personal. And don't get personal about opposing counsel. Stay focused on the issues, because the judge is not going to sit there and try to be a counselor. The judge's job is to be the decider. So don't get personal and don't engage in personal attacks, because that's a good way to undermine your credibility with the judge. So let me point out that the judge is not the advocate. And the reality is the judge is never going to know your case as well as you do. Point blank, I'm not you. And so please understand the judge's role and the time constraints that the judge has. That means your job is to take the issue and to synthesize it down. And rather than filing massive amounts of briefs, or rather depositions, that you have not gone through and highlighted those portions that are significant, it's really important that you clearly understand what are the key pieces of fact and information you need to have in front of the judge, and that you synthesize it in a way that is most persuasive to your case. If you expect the judge to become you, to know your case as well as you do, well, there are judges that have a reputation of doing that, but the reality is that's not going to be the norm simply because we don't have the resources. So help me, help the judge help you. And that should be your mantra. But of course, also keep it simple, keep it focused, and keep it organized. And finally, let's just end with this. What's the first rule? What's the first words, or pretty much the first words out of your mouth in a motion? Yeah, that's right. Tell me what you want.